All right, well, it's after 10, or I think we're still waiting for commission attorney for one. And so let me just review with you Attorney Valsvik. No, let me just hear how to spell your name. Say your name.
Walsvik, Your Honor.
Walsvik. I'm not gonna have to remember
Just like
that.
it's spelled.
Oh, but I read it differently. Oh, forget it. I won't explain.
I know.
Nicole Hutchinson, not sure who she's with. Well, okay, so Attorney Valsik, is there, or do we expect anyone else to be connecting, or we have everyone we're looking for?
I believe we have everybody we're expecting, Your Honor.
Yeah, that makes sense. Oh.
Mr. Vickerman's not going to be here today, correct?
Oh.
No, he's not. And I guess we could remove him from the service list if you'd like, Your Honor. It's the email is defunct now, I think, but
Officially retired?
yes, officially retired April 20th, I believe.
Yeah, he's missing all the fun.
I think he's gonna have his own fun.
Yeah, it's about time. All right, well, looks like we have everyone we're expecting. So let's get started. We'll get on the record now. And this is docket 5780 TE 111, the application of the city of Sturgeon Bay for approval of revisions to its parallel generation tariff. This is Michael Newmark, the administrative law judge for the PSC. We're connected through Zoom with parties and commission staff in attendance at this time. This is also a public hearing as well as a party session. So we will take comments from the public if any do appear. At this time, I see a few names that I don't recognize. So we can take public comment for people who are not affiliated with the parties or staff. I guess just one person at this point. So it looks like Nicole Hutchinson. If you're not affiliated with a party, if you're a member of the public and want to make a comment, we can unmute and have you do that. Maybe just listening in. Okay, well, if I don't forget, I will provide another opportunity for comment, possibly at the end of the hearing. So if you are a member of the public and change your mind, we'll capture your comment live today. We're also accepting public comments in writing, and the process for doing that is in the notice of hearing. So they can be those comments can be filed on the commission's website or mailed to us. They are due by Thursday, May 9th. So, and just to know, we do have a significant number of comments filed on the commission's website at this time. I did not check the number at this point, but there's quite a few of them. So thank the public for participating that way. So since we have no people in attendance that wish to make a public comment, we'll switch to the party session. So let's start off by doing our appearances on the record. We'll just start in alphabetical order with the Public Service Commission.
Sophia Rogers here for commission staff.
Right, and Renew Wisconsin.
Ori Walsvik here for Renew Wisconsin.
And Sturgeon Bay.
Kara Lair and Jacob Neely from Perkins Coie for Sturgeon Bay.
Okay, and I note that we'll need to change the list by removing Michael Vickerman from the Renew listing. Any other corrections or adjustments we need to make to the service list at this time?
Your Honor, extraordinarily minor ones, if you don't mind.
Okay, we can go off the record. Go ahead.
Sorry, before you speak, can I just get your name again?
Sure, it's Kira, Kira, Lair, Loehr. We've just got a little bit of typos in its Sturgeon Bay for the references to me and Jacob and Ann and WPPI, and that should just be Sturgeon Bay Utilities.
Right. Okay.
And then if we could add Jim Stawicki to the reference to general manager.
Oh, I'm not sure what.
It's just, instead of just the reference general manager, have his name as well.
Okay, so this one is actually, I'm not gonna be able to change the list. This is sort of just a printout, a report that I'm sharing, but the list itself is gonna look like that because it's the utility primary contact that the utility
That's fine.
creates.
Okay,
So you know, yeah, so I just copy, I automatically put them into a case, put that contact into a case, just as a matter of course, so that the official email is sent, is served everything. But yeah, so it's whatever the utility had entered will be what we see there. So yeah, Sturgeon Bay, that's strange because they all should be copied off of each other, but that's what happens when you cut and paste the wrong thing. So okay. Okay, so anything else? Anyone else for the service list? Okay. All right, so we can remove the notice here from the screen share. So we have a number of preliminary issues to deal with. Let's get back on the record for this. Oh, had someone else. Okay, so a number of preliminary issues. We have the offered evidence list. So I'm just going to bring up my live version of that. Parties and staff received a PDF copy and an email sent on Monday. Looks like from the issues were being presented here and the sort of like the new filings we've seen in the case that we'll be needing all the witnesses for parties to be in attendance. So we won't go through excusing anyone at this time. But in terms of the offered evidence list as it sits here today with the current filings, I just want to make sure we have the filings identified correctly. So any corrections we need to make to the list that you see on the screen share. So let's start with Sturgeon Bay. Probably the best thing, just to
no, Your Honor.
no changes. Renew Wisconsin, any changes to current list?
No changes, Your Honor. Just note the Cal 15. I'm assuming we'll talk about that after we go through. Okay. Yep.
Yep. And commission staff?
No changes, Your Honor.
Okay. Yeah. So now let me ask about questions about any of the comments. So I'll start with Sturgeon Bay. Any comments need clarification, further explanation?
Just one question, Your Honor. So we will be preparing Exhibit SBU application because we did inappropriately call that Exhibit SBU Nullner 1 in the first instance. Is it more confusing to leave that in or take it out or try to substitute it?
I just leave it in. It'll just be a convenience to have the application, in that application exhibit, and also to have the additional links. I have something else in here, right? So let me scroll down.
You
Yeah,
mentioned the black line version, yes.
So we add that in as well. That'll be useful, but Nodler 1 can just stay in the record as is.
Okay, thank you. That's the only question.
Okay. Make sure I didn't have any. All right, and Renew, any questions about the comments?
Not a ton, Your Honor. Just had a question on the use proper confidential filing. We had
yes.
uploaded.
I'm gonna go over that after
Okay.
after we get to the details of this, but yeah, that we'll definitely want to talk about that. Anything else just about the kind of the nuts and bolts?
Yes. So not about the nuts and bolts, but is the idea that there'll be another exhibit that Mr. Kell will prepare with the currently filed PGS 1 and PGS 2 tariffs? Is that the thought there?
Yeah, let me check that because that may have. Yes. Yep. The ones that he's citing on in rebuttal.
Okay. Okay.
So if we-
So prepare and submit those. Okay.
So there's a cover page and then the cited tariff sheets. If the tariffs have their own title page, the title page should be the first document you see for each utility's tariff sheet. But I know some of them don't. Well, munis anyway don't have a title page, but the IOUs probably do.
Okay. Then I don't think we have any questions other than those two.
Okay. And commission staff, any? Oh, sorry. Any questions about the comments?
No, we'll get that filed when the comment period closes in a couple of days, or if it's extended, we'll do that timely. And then, we did, looking back, find some more, typos and, an erroneous citation to FERC Order 872 that really should have been, just the WIPI specific, order. We'll correct that and we'll, describe those typographical corrections in, our service email.
Okay, yeah, at this time, we probably want to just review those on the record when witness Mumins takes the stand so that the record reflects the correct version.
Okay, thank you.
Yeah, so to do the best you can with that.
Will do, thanks.
Okay. All right, so yeah, so we're still on the record. So I just wanted to make sure there's a couple of important documents that seem to they're not lost. It's fine the way they're filed, but I just want to make sure we give the commission a little bit of a roadmap here. So I just wanted to make sure that we all agree, if I got this correctly, the state for the record items. So do they look correct to everyone at this point?
Your Honor, I believe that Kel 11 is just the PCAC tariff.
Oh, okay.
And then the exhibit to be filed, Kel 15, would be the PGS 1 and
yeah,
PGS 2.
You're right. So I got ahead of myself there.
Otherwise, that looks correct to me.
Your Honor, I'll let you finish that, but there is one more correction.
Okay, yeah, go ahead.
The first one, the reference to the long-term power supply contract, it's actually at Exhibit SBU Stawicki 1, not 2.
Uh-huh. That's why I'm asking. Right. Okay, so the rest look good. All right, so let me just state for the record just a couple of important items, important documents that are and where they're located in the offered evidence. So the WPPI long-term power supply contract is located at let me just say Exhibit SBU Stawicki 1. The WPPI schedule for firm requirements service is located at Renew Cal 7. SBU's current PCAC tariff is located on Exhibit Renew Cal 11. And SBU's current PGS 1 and PGS 2 tariffs are located in the to be filed Exhibit Renew Cal 15. Hopefully that'll help in navigating the record. All right, so yeah, I did want to discuss 3 other items looking at some of the filing requirements. First of all, the confidential filing process, and I'll include also sharing process, service process. The prohibited markings on original filings offered as exhibits, and then just generally when making references to tariffs, offer a copy of the tariff as an exhibit. Just start with the last one first. Not too much to add to that, just that tariffs are usually pretty difficult to find. the commission's website does have a way to get to a utilities tariff fairly simply, but then finding the specific sheet can be a burden. So so for the benefit of the commission, just want to make a note of that in future cases to just offer the copy of the tariff as an exhibit. And that's not something that's been required before, but I may just want to add that in to our requirements because it does help very much in the process. And from the bottom up here, prohibited markings on original filings offered as exhibits. I think mentioned a number of those on the offered evidence list. And I just want to show you, there were no questions, but I just want to make sure everyone's on the same page. And for the benefit of others, this will be on the YouTube recording, but just to see if we can manage to show what I'm talking about here. So hopefully this will be a good one. This is just Cal 10 filed in the case. And no, that's not a good one. What was I talking about there? Okay, yeah. So it looks like there's like a bait stamp number on this exhibit in particular. So the issue would be this is an original document filed at the commission. It's a piece of offered evidence submitted in another docket. And I'm referring to Exhibit Renew Cal 9. So it does have like a bait stamp number that just runs through the entire document, including the cover page. So you just want to keep that off of the document. You want to present the original document as you found it, as you possess it, rather than one that's marked with some additional information that you've placed on the original. So if it came this way, that's fine. If that's the version you have, that's what we have to work with. But please in the future don't add information to an original. And then that goes also for like highlights and notations. Unless were there before you got it, we should just put in a clean version. In terms of highlighting sections, I mean, you could take out a quote, put it in your testimony. There's other avenues for bringing out particular piece to bring that to the commission's attention, but rather not have the originals adulterated in any way. So I hope that's helpful. And then more complicated is this confidential filing process. So I think I'm just going to deal with the easy part first, which is in the facilitating matters order that's attached to the scheduling order in the case. There's one provision that speaks about sharing confidential documents we have that there's a claim for confidential handling, either pending or approved at the commission. Those documents, if they're in testimony or exhibits, they need to be served. Service is through email, and email is not secure. So in order to preserve your claim to confidentiality, you want to do your best to keep things secure, keep that information secure. The way you would do that in service is to password protect those documents. So with Adobe, you can encrypt the document with a password. So you'll need to share the password with parties and staff and then send that version with the password protection. So that's one element of this, the proper confidential filing. I noticed that the SRSA rebuttal from SBU was just shared by email, the confidential versions, and was not protected by password. So unfortunate oversight, I'm sure, but we want to be careful to adhere to that standard for everyone's protection. In terms of the filing of a confidential document. I'm going to open the renew rebuttal, the public version. Put that on the screen share. So I see that what was contemplated here, what Renew had done in order to make a claim of confidentiality is to attach this affidavit to the first page of the testimony. And the confidential version's got the same information. These pages are identical, but there are some deficiencies in this claim. So now I realize that Renew doesn't have the information. It's basing its claim on SBU's assertion that these documents are confidential. This is information provided by SBU. But the most important thing is that in terms of our process, that this statement has not been notarized, and it needs to be a true affidavit that when signed and notarized. So so the filings that Renew has made, there's another exhibit as well. I think it was exhibit 12, also has a similar attestation, but no notary, no signature and notary seal. So we want to correct that process, that deficiency in this case. So they'll need to be refiled using the proper process. But more importantly is that there is a much easier way of doing this. And I don't know, maybe there was a choice in not using the electronic filing for an electronic request, but it is, I think, the preferred way. So if you're not familiar with it, we can just review that quickly. So we go to upload a document on Earth. You'll see confidential. I'm not gonna be able to do this on my account. So, okay. Let's see. May not make me. Oh yeah, here we go. So here's so if you're going to be filing a document on Earth confidentially, you fill out this form that's on the screen share here, complete the confidentiality request, and then section 3 is it's basically the electronic version of this affidavit. So if you have a choice to attach an affidavit to your document or fill out the form, and the form basically will supplant the need for that affidavit in writing. Important thing is that the notary officer needs to be present when the affiant is filling this out and uploading the document. So and that can be done with someone on a Zoom connection, that's perfectly okay, but just have the notary officer present while these boxes are filled out, name of the notary officer, expiration date of the notary authority, and then upload your document. So then this will be recorded in the commission's IRF system. It won't appear on the document on IRF, but it'll be connected to the document. And that's what most people are doing now. It's just much easier. And it also supplants the need for having notary stamp that page. And then you'll need to scan it in and create your exhibit from there. So let me just ask Attorney Vasek, any question about that?
Yes, Your Honor. Just a couple clarifying questions. So the notary here, that can't be the person who's the owner of the account that's uploading the document. Is that right? Because
it can't be the affiant, but it can be the owner of the account, I believe. Yeah. I don't see why that would matter.
Because we had filled this out, the affiant as Mr. Kell, and then I notarized it using this process, I guess. But we just also included the affidavit. But I guess we can remove that.
Yes.
And go forward. And then also I had mistakenly filed the public versions initially separately.
Mhm.
And then there's the paired versions. I believe those have been removed. And just wanted to make sure that there's nothing we have to change there.
No, you're correct.
Okay.
That's fine. So
Okay.
yeah, if you just want to refile, you can just remove the printed affidavit on the document and just rely on the electronic version. The prior
Okay.
versions we made unacceptable on Earth, so they just or I think we just titled them differently, so they will remain as testimony offered and not received into the record.
Got it. Thank you.
Okay, good. I'm glad to clear that up. Okay. All right, so I think that's all that preliminary. Okay, so next on the list is the ruling on the motion to strike. We did have a second filing, an answer from Renew on the substantive portions of the motion to strike from SBU. And so at this point, so let me just be clear. So this is a motion to strike the surrebuttal of Renew witness Cal. Let me get this document in front of me. And I believe those portions are sections 2 and sections 5 of the surrebuttal. SBU filed that motion to strike Renew, answered in 2 parts, one addressing the SBU's request for expedited treatment. That's fallen away. That's a moot issue at this point. And then also Renew filed an answer on the substance of the motion. So at this point, I can hear any response or reply from SBU.
Thank you, Your Honor. Our primary concern remains the issue of timing and the fact that Renew does not seem concerned with the proper timing of when to file things. Every single aspect of Section 2 of surrebuttal PSC Kel could have been filed in rebuttal testimony in response to Mr. Mulliman's direct. That is exactly how it reads. That is exactly when it should have been presented. I frankly cannot understand their rationales for why it wasn't presented at that time. They also offered zero rationale for why the Section 5 was not presented earlier than surrebuttal testimony, particularly since it appears that Mr. Kell was aware of this proceeding.
And when you say this proceeding, what are you referring to?
I'm sorry, was aware of docket number 4139 TE 102 that Mr. Kell's surrebuttal testimony refers to. The timing matters. The order and the narrowing of testimony matters. When you don't have that narrowing and when those rules are disregarded, you get things like the surrebuttal testimony that SBU has put in at this time in this proceeding. And it is extraordinarily difficult and incredibly prejudicial to SBU to have to scramble at the end, 6 days before the hearing, to respond to all of this and have to do that because it can't take the risk otherwise, because the hearing is happening on Tuesday no matter what. And the fact that Renew's response to that is, well, you're going to put in testimony anyway, go ahead and just add to it, is very difficult for SBU to fathom why that would be a reasonable response.
Okay. Did commission staff want to chime in on the issues?
Yes, Your Honor. Commission staff shares the frustration with the lateness of the New Richmond, the Section 5 filing. We don't object. We don't support striking the Section 2, the responsive testimony to Mr. Mulliman's direct. It's sufficiently narrow, and while we recognize Renew should have filed this earlier, it's not putting a wrench in the proceeding the way that the New Richmond information is. So we do want to share the frustration with the difficulty that introducing this evidence at Sir rebuttal has created, not just for the applicant, but also for commission staff. And commission staff this morning, just receiving this Sir rebuttal, is unable to review and respond to that today. If, you know, pending your ruling here, this new evidence really required a change in schedule. We do feel it's relevant to the avoided capacity calculation. And so, unfortunately, we're going to have to agree that it needs to be reviewed by the commission. And it's up to you, Judge, to weigh the relevance against the frustration of the process here. But commission staff would like to see an extension of the schedule so that we can adequately review and understand this evidence and how it might affect the commission's decision and give the commission proper alternatives as to calculating avoided costs. So we wholeheartedly agree with the applicant's objections here, and we're really disappointed to see the schedule fall apart this way, pending your ruling. You know, we did all come to agreements on when testimony, how it would proceed, and this does violate the schedule. But it's our read that this is relevant enough that we would like the commission to see it. We think it's going to lead to a more robust record and better reasoning by the commission. So we would like to see it in.
Okay. Anything for Renew to add?
Sure, I'll just add 3 things, Your Honor. First, the Sir rebuttal you got this morning, I definitely agree that it addresses the New Richmond issue, but as discussed previously and filed with my Exhibit A, there was going to be Sir rebuttal this morning, not just on the PPA data, but on other unknown items. So, you know, that was already contemplated by SBU. At least I guess I don't know if they were going to elect not to file it, but that's what they represented to us when we were discussing the proper timing of testimony here. Second, we asked for this information in discovery. We didn't get anything. We didn't get something that said there's information out there, go look for it. We got, there is nothing. And so, you know, I understand that Mr. Kell's name appears in the docket, sold as Mr. Noldner's name. Mr. Kell wasn't involved in 2015 when this was originally decided. He was involved.
By this, you mean what?
The New Richmond proceeding, wasn't involved then. His name appears in 2021 in January, and he began working for Renew about 2 months later. So he was very, very lightly involved, I guess. I don't want to, you know, he's here, we can ask him about his involvement. I don't want to characterize it myself, but, you know, to the extent that he knew about it, we would have put it in earlier. You know, this isn't some attempt at surprise or to frustrate the timing of the proceeding, but, you know, it's more of a function of its relevance. But we, you know, we do share the concerns. I understand there's a concern of surprise in response and undue prejudice. You know, unfortunately, we believe the best way to mitigate that prejudice was to put it in when we put it in and not wait until today or later. But certainly, you know, understand the concerns there. So I think that's our general response. The only other thing I would say to the discussion of the Section 2 Sir rebuttal of Mr. Kell, it's Renew's assertion that it's properly responsive to Mr. Noldner. If you review Mr. Noldner's rebuttal testimony, you're finding blending all over of Mr. Millman's and Mr. Kell's testimony. At some point, he says, Mr. Millman's and or Mr. Kell say XYZ. And there's definitely splits there, but to the assertion that it's can be read as directly responsive to Mr. Millman's, I think it can also be read as directly responsive to Mr. Noldner's rebuttal. But I won't beat a dead horse there, Your Honor. So I think that's just our comment.
Okay. So I was actually going to take the sections one at a time, but since you raised the issue of the discovery response from SBU, let's just get SBU if you could give us a little more or your opinion of that statement. I think the response we're referring to is SBU's response to renew INT 2. Which speaks of getting the avoided cost information of WPPI regarding transmission costs, and SBU responded with a statement that, and I'll just read it, SBU interprets this request to be seeking analysis in SBU's possession, custody, or control of transmission costs that may be avoided due to the presence of distributed energy resources on SBU's system. There is no such assessments. So I think the claim or the assertion is that that was an incomplete response, and I'd wonder if SBU had an answer for that.
Yeah, yes, Your Honor. Thank you for that opportunity. It is a fully complete response. It is a fully complete and accurate response, exactly as you read it, as it was written, when it was provided, whenever it was provided. SBU is not WPPI. SBU is not New Richmond Municipal Electric Utilities. The statement is exactly as it stands.
Mm-hmm. Okay. So let's begin with my ruling. I have something written down here. Nothing's really changed, in my opinion, from what I've written. So I'm going to proceed through it and maybe just break for a few questions and some tangents. Hopefully, not too many tangents. So dealing with the motion to strike, surrebuttal, renew, Kell, sections 2 and 5. Generally, SBU correctly describes the law that governs the procedures to filing written testimony and the restrictions contained in the facilitating matters order to ensure the records of each commission proceeding is complete. Significantly, completeness of the record includes the opportunity to vet any offered evidence. Therefore, the necessity to both complete the record and provide due process required under Wisconsin statute section 227.45 coincide. Generally, renew accurately distinguishes the offered evidence at issue with that presented by the Huda-Vierniks, and I can spell that for the court reporter. It's
Actually have it.
okay, great. Yeah, I'm sure you do. So it's the issue presented by the Huda-Vierniks, which form the basis of the law cited by SBU. Notably, Renew's testimony is untimely filed, while the Huda-Viernik evidence was practically impossible to rebut. However, Renew's arguments on those grounds do not on their own save the evidence at issue from the consequences of being untimely filed. To implement this goal, the commission has ordered the application of the facilitating matters order to this proceeding. In particular, to this situation is FMO section 3.A. And just briefly put that on the screen share here. And you can see in that section, it talks about the rounds of testimony, what to do if you want to file testimony out of the scheduled rounds, and what the rounds should include. We'll get to the details of that in a moment. But that's basically the rules we want to follow. But before we apply these requirements to the issues raised in the motion, I want to know whether section 2 of the surrebuttal presents any assertions of fact not already contained in the previous rounds of testimony. as far as I could tell, perhaps only pages 4 through 6, with respect to capacity values, include new assertions of fact. So I'm wondering, I guess what I read in the surrebuttal was a lot of restating the record, either what previous witnesses have stated or the answers provided by Cal, the direct testimony of Cal. I didn't find very much or anything at all new in the surrebuttal. So I wanted to just parse that out and make sure I was understanding that correctly. And bear with me here, I'll get that for us. I think I will anyway. Here we go. Many screens. All right, let's stay off the record for a second. I'll just find this in a different way. Seeing it here. Okay, so I have the public version. Okay, so let's get back on the record. So I'm displaying on the screen share the public version of the Cal rebuttal. So yeah, just notably, I think most of the answers, first of all, there's a lot of restating what other witnesses have said. And then most of the answers are just either confirming agreement with PSC staff or restating testimony from Cal Direct. So there's a portion here of page 4, I believe, starting on line 18. What do you believe is the appropriate way to reflect actual capacity values? I think that answer is also restating the direct, maybe slightly adding some nuance, but I don't think there's really much new in that testimony. I just wanted to confirm, is that a fair statement, Attorney Vasilic?
Your Honor, to my knowledge at this time, yes. I think maybe the PCAC reference, because that wasn't in the record at the time, is new. But you know, it's generally speaking to the same suggestions that were in direct.
Okay. Yeah.
Assuming we're just talking about section 2.
Section 2. That's
I'm not
correct.
trying to say that section 5 was indirect.
No, you're right, and I agree with that. But you know, either way, I think we do want the PCAC tariff in the record, which is why we will have you. That'll be. We kind of discussed putting that in as an exhibit, but in my opinion, I think we're looking at what's occurring in section 2 is restating the existing record before we got to rebuttal. So, let me continue with the prepared response I have. I don't think it's changed again. So first of all, section 2 clearly responds to staff direct. Therefore, Renew should have filed it as rebuttal. If Renew had a reason to file rebuttal past the deadline set in the schedule, it could have asked for an adjustment to the schedule for which I had previously invited parties and staff to file, should it be necessary, given the discovery dispute resolved earlier in the process. Renew failed to make such a request, and for this reason, Section 2 should be struck. Second, striking Section 2 produces no substantive effect to the record because Section 2 contains no new information, at least nothing probative. Instead, the evidence offered merely repeats previously filed testimony of the parties and commission staff. So in addition for being untimely filed rebuttal, Section 2 is struck for being unduly repetitive. While I don't perceive Renew to have intentionally crafted its rebuttal to skirt its duty to timely respond to staff direct on rebuttal, skipping a round of testimony to see what the other side has to say about other participants' testimony is a disservice to the record and an abusive process. Simply put, rebuttal is a party's opportunity to respond to direct. Surrebuttal is a party's opportunity to respond to rebuttal. Failure to offer evidence on these terms is detrimental and must be prevented. So I did want to also, while we're here, emphasize that it's not necessary. And well, let me just add. So the summarization of previously filed testimony is unnecessary and repetitive, just by obvious logic. Therefore, if the substance of a witness's response to previously offered evidence is only to refer back to testimony, it should be a very brief statement that the witness's position is either not changed or they're in agreement with what has been presented in the next round. And just so you know, it's really not even necessary to disclaim that your position is not changed because it's embedded in the facilitating matters order section. Section E 6 and 7. So that actually will tell you quite clearly that failure to rebut or surrebut the testimony of another witness does not imply consent to that testimony. Witness must expressly recant any prior testimony. A witness need not repeat or restate prior testimony to retain its position on any matter. And number 7, the testimony of another witness speaks for itself. A witness should refer to the testimony offered by another witness by citation rather than restating it whenever possible. So I know there's times where it's beneficial to provide a quick summary. I know I've seen like tables and charts that do that, which are very helpful. So I don't want to discourage that, but instead of narrating through pages of repeating what's already in the record, it's better to let it speak for itself and use a citation. And that'll be helpful in the future. So let's move on to section 5. So in section 5 of the section 5 of the surrebuttal presents a comparison between the avoided cost debated in this instant case with the avoided costs approved in the New Richmond case. That's docket 4139 TE 102. I find this testimony introduces a new issue into this proceeding. The rounds of testimony filed after direct shall introduce no new issues. That's FMO section 3A4. Renew in its answer to the motion to strike provides reasons why it failed to present this issue in its direct. However, the proper process to assert new issues after the deadline to file direct is by filing supplemental direct, together with a request for leave to offer additional evidence. That's FMO section 3A3. I won't bother showing you. It's there. Such request triggers the due process opportunity for other parties and staff to review the evidence, present objections, and request additional time to respond. Had Renew followed the proper procedures, the matter before us now might have been resolved prior to the hearing in a significantly less complicated and more orderly way. For failure to offer section 5 under the correct procedures, it may be stricken. However, Renew's answer raises a serious allegation with respect to the potential withholding of information by SBU with respect to the analysis WPPI conducted in the New Richmond docket. Renew discovery request number 2, Renew INT 2. That's the request I'm talking about. So the request states, I'm going to read it. Well, I'm going to paraphrase it. Let's see. I'll put it on the screen. Request states, pursuant to page 2, footnote 4, and page 3 of SBU's application, identify all assessments of avoided transmission costs. Then it asks to provided by WPPA to SBU, provided by WPPA by American Transmission Company or its affiliates or subsidiaries, and also provide assessments of avoided costs undertaken by WPPI itself and are completed for WPPI by a third party or contractor. Now, the response to renew INT2 is found in PSC reference 493335, and it states, important in part, SBU objects to the interrogatory as overly broad, burdensome, vague, improper, and not reasonably calculated to lead to the discovery of relevant information, in that the interrogatory is not time-bound. The phrases, in quotes, assessments of avoided transmission costs, unquote, and quotes, avoided transmission costs, unquote, are unclear and undefined, and neither WPPI nor any third party or contractor, and those are in quotes, are parties in this proceeding. Subject to these objections and without waiving the same, SBU interprets this request to be seeking analysis in SBU's possession, custody, or control of transmission costs that may be avoided due to the presence of distributed energy resources on SBU's system. There are no such assessments. Now, we had a little tete here on that exact issue here today, gathering some little more information on that response. But I can continue here with my written statement. This response relies on SBU's self-imposed condition on the request as being limited to any assessment in SBU's possession, custody, or control of transmission costs. Therefore, the response is legally complete. But while the response is legally sufficient, it also obfuscates reality, but by not fully answering the actual question presented. I find this response to be made in bad faith. This reality must be addressed and corrected. WPPI is acting as SBU's third-party consultant in this proceeding. It prepared the application in this proceeding and all the underlying analysis used to support its application. WPPI provided the same services to New Richmond in docket 4139 TE 102. WI's employee, witness Nodler, in this instant proceeding is a participant in the New Richmond docket. So WPPI is well aware of its assessment of avoided costs it prepared in the New Richmond case. Had SBO applied good faith to this response, it would have consulted with WPPI in preparing the response and at least directed Renew to the existence of the New Richmond docket. However, SBU failed to do so. On the other hand, Renew retains some responsibility for not learning of the New Richmond docket by failing to exercise all its rights to discovery. I know there's also some, and in a tangential comment, I know there's also some information that witness Cal may have been involved in the New Richmond docket, but I think what I want to focus in on is what Renew could have done in the process of this instant docket. I think it did have rights that it could have exercised. So Renew could have moved to compel SBU to produce a more complete answer to Renew INT2. Renew could have deposed witness Nodler and others from WPPI to gain a more complete understanding of the basis of WPPI's assessments of avoided costs. With respect to another interrogatory, to Renew INT4, I believe I got that right. It might be the request to produce, but anyway, Renew moved to compel production of information SBU claimed that WPPI, not SBU, possessed. I granted that motion. During the motion hearing, I outlined other options Renew could have employed, including depositions. However, Renew failed to exercise these rights with respect to Renew INT2. Therefore, the existing response to 2 renew INT 2 fails to provide a sole reason adequate to justify the untimely filing of Section 5. However, it does provide the basis to correct a related and more basic procedural problem underlying this proceeding. Given the unnecessary procedural confusion caused by the legal veil WPPI dons with respect to the member utilities it serves when preparing and participating in the rate proceedings of its members, as evidenced by SBU's response to 2 renew INT 2, I find that it is necessary and convenient to the Commission's jurisdiction to name WPPI a party to this proceeding and any other proceedings in which WPPI provides support to a member utility going forward. This way, the complete set of facts in such proceeding may be obtained and a complete vetting of an application may occur in a timely and orderly fashion. While under the FMO, Section 5 was filed untimely, and while Renew's claim for receiving incomplete response to discovery fails to present a determinative showing of good cause to have discovered the New Richmond docket after the deadline to file direct, other duties imposed on the Commission present a basis for receiving this testimony. Our duty to complete the record may allow for the receipt of evidence procedurally misfiled. We typically receive filings that violate the filing requirements of the FMO by allowing a violating party to refile a corrected version of the offered evidence at issue. But these violations are usually non-substantive in nature that impact no due process protections of other parties. In addition to admitting evidence procedurally misfiled after the correction of formatting errors, Wisconsin Statute Section 227.45 sub 1 directs me to admit all, and this is quote, admit all testimony having reasonable probative value, unquote. Of course, as established in the Huda-Vernick order, evidence may only be probative if it receives an adequate vetting. Therefore, even when evidence is offered in violation of the process set up in the FMO, I need to rule on whether the evidence should be admitted under 227.45(1). And this admission can only occur if the process allows the required opportunity to respond to the evidence. So at this point, I do want to find what I've read so far in the Section 5 New Richmond evidence. I want to find that it does have probative value. It is relevant to the case. I think I've heard Commission staff and Renew assert that here today. And it obviously does, it's a new issue in the case, but the comparison of the avoided costs between SBU's application and the ruling, the order avoided costs set by the Commission in Richmond are a valid issue in the case. Oh, so I actually wrote this better than I just said. So I'm just going to read it. So now I want to. So now when we're talking about the probative value of Section 4, I find the evidence is probative value. And now it's our task at this point to determine what due process can be provided to allow its admission. So we can move on to that. Yes. Okay. So at this point, we do have the surrebuttal Section 5 substantial portion of new information being offered for evidence, and we also have what we just received by email, the surrebuttal of SBU, in part responding to that testimony. I have not had a chance to review the surrebuttal. In fact, I wanted to note that page 4 of the Facilitating Matters Order Zoom supplement directs parties and witnesses, it expects party and witnesses to have all offered evidence and exhibits in hand and accessible for their use during the hearing. But also, in addition to the documents filed on the schedule that will be provided in the offered evidence list. We also have a statement on that, in that order, that a party or commission staff, when a party or commission staff wishes to use at hearing, let me read the whole thing. Okay, so it says parties and witnesses are expected to have all offered evidence and exhibits in hand and accessible for their use at the hearing. The ALJ will share the offered evidence list by email to the service list. For any document not on the offered evidence list that a party or commission staff wishes to use at hearing, the user shall share that document by email to parties, commission staff, and the ALJ no later than 1 day before the party hearing session at 1:30 p.m. Now, my understanding is the SIRSA rebuttal, the written form, which is in response to Section 5 of the SIR rebuttal, came in just within the last hour by email, and was not, the confidential version wasn't submitted till later and was not submitted properly in an encrypted version. But that's all just to reiterate that we accept things that have been misfiled, not filed according to the FMO, but we need to come up with a process in order to vet all of this evidence. I believe commission staff has already indicated that it does not have enough time today to vet SIRSA rebuttal and work out a response if necessary. So I guess we really have two options. We could proceed with the rest of the hearing today and then hold the issues raised on Section 5 of the SIR rebuttal for another day, another time, or simply reconvene the entire hearing on another day. So I will open that up for discussion. Someone wants to chime in there. Yeah, go ahead, Renew.
Yeah, so maybe this will make it easier for SBU to respond, but we did briefly, obviously, review the SIR rebuttal this morning. Notwithstanding the fact that it's responsive to the SIR rebuttal, not just the Section 5 or the PPA, but also Mr. Millman's and Mr. Kell. Notwithstanding that fact, Renew, I don't believe we need extra time that we would need to postpone the hearing today to review this. I think that we would be okay proceeding forward today without extra time. So I understand that staff has said they need more time and don't want to take away from that, but that might make things easier for SBU to figure out where it's at.
Well, yeah, go ahead, Sturgeon Bay.
Your Honor, I recall you emailed yesterday that you indicated that you had a break in the day today. You had another hearing that is scheduled for early this afternoon. I am curious if commission staff believes that if we took a break and reconvened after that hearing, whether that would be enough time.
I believe the answer is no. I'm just checking. So we have some limited availability this afternoon, but I think it's not going to be realistic. I'm just checking in now.
Your Honor, the other piece of information is based on the SIR rebuttal. We don't have any planned cross for Mr. Stawicki at this time.
Right, okay.
Judge, safe to say we would be more comfortable pushing this back.
Yeah, I think one of the problems maybe parties don't recognize is that witness Moomins is going to have to be observing the hearing instead of reading the testimony. So that really does create a distraction in order to fully vet the SIR rebuttal. It is quite lengthy. And I know that's not undeserved. I'm just saying that it is substantial. So it's not something that can be taken lightly and scanned through. So I do appreciate taking the time to get this right. I don't know if it makes any sense to go through the other issues and witnesses or just simply adjourn and reconvene at another date. Any desire? We still have about an hour, well, about 2 hours till my next hearing. So
Your Honor, would you be amenable to just a pause in these proceedings to discuss?
yeah, we
however
can
that
go. We can go into
works?
recess if parties and staff want to talk about it. Yeah. I'll put you in a breakout room so we can continue the live stream. So you'll see that I think it just puts
Are we
out.
off the record? Are we off the record?
Yeah, we can go off the record now. Yeah. Thanks.
Your Honor, could we have a little bit of time even outside of the breakout room? I need to talk to folks.
Okay. Sure. Well, we can come back at noon. How does that sound?
It could even be probably well before that.
11:30. How's that? But you
Okay.
need to talk to the parties too.
Right.
Or staff, maybe more so. But I would I would keep everyone cognizant of the fact that staff won't be able to do much of this review today. So we're most likely not going to be getting to the Sir rebuttal. Well, but we could address other parts of the testimony today.
Okay.
So why don't we adjourn until 11:30? We'll just shut it all down. Yeah, yeah, let's just shut it all down. We'll reconvene at 11:30. All right, thanks.
Thank you.